Hello, everybody, and welcome to Sullivan and Cop presentation part 7 on the COVID virus. If you're listening to this, you have probably listened to at least one prior webinar that we've been putting on through Sullivan on Comp. It's a whole series on COVID-19, how it relates to workers' comp and how it relates to employment law. And we're working through the issues seminar by seminar. One at a time. But before I go more into that, I will go ahead and introduce myself and my large-headed friend, Adam Dombchik. I asked him if they could shrink your head for this one. But
He asked me for a picture, and all I could find one was a smaller head, but with hair, and I didn't think that was accurate.
That's not fair.
Being that accuracy is important in workers' compensation, I stuck with the no hair, big head picture.
Wow. I kind of went the other way with it. I'm a clean-shaven man now, and this is an old picture.
That is true.
Yeah, let's just move on.
Okay.
Anyway, Adam is a well-known applicants attorney, and I think we have a slide for you here. But first, we're going to talk about me because I'm more important. And anyway, Adam is a partner with. Oh wait, I'm talking about me. Sorry. Keep forgetting. I just get entranced with just looking across the table at you. Sorry. But I'm a defense attorney, right? So Michael Sullivan and Associates has, I think it's 9 offices throughout the state, and we do workers' comp defense. But we've over the years added employment law, immigration law, insurance litigation. So we're trying kind of a full service law firm for employers in California. But when I talk about Sullivan on Comp, Sullivan on Comp is a big legal treatise, and if you're listening to this, you're probably a subscriber or know someone who is a subscriber or aware of Sullivan and Comp. It's pretty ubiquitous. I think we have over 6,000 subscribers. All the judges, a lot of firms, a lot of claims outfits, a lot of applicants attorneys. Anyway, when I'm doing Sullivan on Comp, I try not to be a defense attorney. I try to be neutral, and the text itself tries to explore all the issues, the different options, the different positions people might take. So to the extent possible, I'm sure my defense bias you would think would creep in there, but Adam will correct me if it does. But Adam is unapologetically applicant oriented here, right? He's made a life of representing injured workers. 30 years, really? Boy, I knew you when we both got started back at the board in Santa Monica.
It's crazy.
Been 30 years. Oh, the law firm's been 30 years.
Yeah.
You've been like 25 or something.
26,
something measly like that. Yeah. So anyway, Gordon Edelstein is a well-established union sort of shop, I think. And you guys do. I've been litigating with Adam for decades, and we used to fight like dogs, and now we have some grudging, measured respect, I think, for one another. And when I put on these things, Adam comes, and I think his commentary is helpful to all involved, defense or not, because when you get both sides talking about something, it tends to eke out the key points. So that's what we're doing. Before we get into it too much, I wanted to point out that we have written a book, Navigating COVID-19. If you were to print this out, it would be about 200 pages. It is absolutely awesome, I think, if I do say so myself. It is. We've emailed it to everybody. If you're listening to this, I'm sure you've been emailed, but you can also find it on our website, sullivanattorneys.com. And it's a complete exposition of all the issues that employers face relative to COVID-19, employment, immigration, and workers' comp, and in some depth, and everything we could think of. And we're updating it on a just about daily basis. So we're not printing it out. It's just a website. You can save it on your desktop. And if you have a question, it's very easy to access the topic that you need to read about, and you'll get a complete exposition as to what we know in response to any question that you have, or any topic relating to COVID-19 in terms of what an employer faces. So super proud of it. Please check it out. It was a lot of work, and we want it to be appreciated. Our plan for today is, like I said, we're doing a whole series of these webinars. We stop at the beginning and talk a little bit about the latest updates, what's on in the news about COVID-19, and we're going to get to that in just one second. I'll let you actually, talk about it first. But we've done a whole series here. The first few were employment law and workers' comp generally. We started talking about workers' comp issues with COVID, and we did one webinar which was just about whether or not you could and should provide the claim form. Then we did a whole one on temporary disability and people that were on temporary partial disability, and if they were released home to go to work with everyone else, whether that would, be something that would get them TTD. And then the last session was the first time Adam joined me. We started talking about AOE COE, and what we said is that generally COVID's considered a non-industrial disease, non-occupational disease, right? And those are considered generally to be not compensable, like the cold or the flu. You don't see people filing claims for colds and flus for a variety of reasons. But the courts have held them to be not compensable because the etiology, how you got the disease, is virtually impossible to determine. However, we spent most of the time last time talking about the one big exception that you could drive a truck through, which is that if you are at greater risk than the general public by virtue of your job, then if you get the non-occupational illness, then it's compensable. And we get a lot of examples from case law and speculated quite a bit about workers that might be in that position relative to the general public. This time around, we want to talk about the second exception to the general rule of non-compensability, and that is if there's a component of work, an instrumentality of work that causes the COVID-19 to come into being, and that overlaps with the idea of aggravation. So if you have non-industrial COVID but an underlying industrial condition, how does that work? And if you have industrial COVID but a non-industrial condition that gets permanently aggravated, how does that work? And then finally, we're going to talk about even more depth about working at home, injuries at home when it's a second workplace, and how that works. And so we're going to kind of wrap up the AOE COE expose here in regards to the basic concept of injury with COVID-19. We're going to have in the future some talks about site claims, right? You don't even necessarily need to have COVID to have a site claim. What if you get stressed out just going home? And how do the defenses work? The 3208.3 and the other defenses. That's going to be the subject of future webinars. So I'm just giving you some context of what we're going to talk about today. But first, in the news, what's in the news, Adam?
So let's get to that. Just one follow-up from our conversation last week. There were a couple questions that issued after last week's seminar about, did Adam think there was ever a situation where COVID would not be considered work-related?
And well, of course not. That's not your job.
I thought it was a very fair question, and I hope I gave a fair answer to some that inquired. But generally speaking, these are fact-driven. This plays into the news, by the way, right?
Right.
They're fact-driven situations, and I think that as we get farther away or into more phases where people are out in the community more often, that the lines will start to blur when there could be an occupational exposure or otherwise, except in the situation where you have essential workers or high-risk workers. And that leads to, drumroll,
there we go,
the news of the day.
Right.
On Wednesday, May 6th, at his press conference, Governor Newsom announced that he signed an executive order making it easier for essential workers who contract COVID-19 to obtain workers' compensation benefits. Essentially, they've created a rebuttable presumption for essential workers that contract COVID-19.
Yeah, that's a big deal. That it was. Well, if you're a listener, a subscriber to Sullivan on Comp, or even if you're a listener, I'm sure you'll get the red alert that we send out. We've issued more red alerts through Sullivan on Comp in the last month than we have in the last 3 years, because this is a red alert. I mean, this changes the whole landscape, right?
It does, and the timing of that announcement, which would assume would broaden the umbrella of those that might be covered for exposure with less pushback, plays right into the topic we're talking about today, because the issues we talk about today are big time issues that have to be considered for both employers and employees.
Yeah. So normally in workers' comp, the burden of proof is on the defense. In fact, we got this news so fast we couldn't even put it in the slides. But one of the slides, the next one, we have, which I can't seem to switch to. The next one is, let me see, sorry, I have a little trouble. Oh, there it is. Oh, that's on the back. Okay, there it goes. Yeah, the basic rule generally in workers' comp is that, it's the burden of proof on the applicant to prove a work-related injury. And we have a series of presumptions that exist for cops and firefighters and other things like that. If your denial's late, right, that shift the burden of proof. And you know what? I always say, what's the big deal? It's not like the defense doesn't really have the burden of proof anyway in workers' comp. I mean, who are we kidding? It's such a liberal culture, right? And then there's 3208 so it's 3202.5 and 3202. And so it's like, I always kind of felt like, well, unless the defense can prove considerably that the injury is not work related, defense is going to lose. I mean, as a matter of culture. And Adam, I know you don't want to admit it, but you know it's true.
I like it that way.
Yeah, you like it that way. And so I don't really see what's the big deal. Well, what is the big deal?
So, I handle a number of public safety cases, and even though those are well-established rebuttable presumptions for certain injuries, they're denied all the time.
Mm-hmm.
And they have to be litigated, and they have to be taught that it's a hill that has to be climbed in order to overcome the presumption. The presumption is given greater weight towards industrial injury. It's even better than 3202.
So you can still deny the case.
You can.
If you have evidence, you still have to investigate, and you have the delay period and denial period. Now, look,
you could probably do a whole webinar reminding those that are affected by that burden shift of the duty to investigate and the impact of not doing it properly. But that's for another.
We did do that. We did when we had the one on
filing the
provision
claim.
of claim form.
Okay.
Yeah, we went pretty deep on that one.
Good.
I mean, the whole thing was just on whether or not to provide the claim form and the applications. It was pretty intense, just for an hour talking about that, Anyway, so look, this was probably a disappointment to many on the applicant side because you guys wanted a conclusive presumption. You wanted it so that if someone was defined as an essential worker, which by the way is a huge thing to understand in and of itself, right? That they'd be conclusively presumed to have contracted this virus on a work-related basis. That's what you wanted. That's what the proposed bills have, and they're still going as far as I know. But the governor only gave a rebuttable presumption. So this is not going to make employers necessarily just pick it up. That being said, a lot of employers, including State Fund, and we talked about this last time, I've already indicated that if someone's an essential worker, they're just going to pick it up. But I don't think that's going to be true for all employers. They're going to have to make their own judgments about what they think is right for them.
Yeah, I think they will. And I do think it's unfortunate that they didn't go the route of making it conclusive. For a limited subset of employees, I think that would have probably saved certain costs related to litigation and maneuvered people back in and throughout the system much faster than the rebuttable presumption. Because again, like I've seen, despite the presumption's existence, claims are often denied, not always investigated timely or appropriately, and you're kind of just back in the same place 90 days later that you were when the claim was first filed. So yes, it is unfortunate, but this is definitely a step in the right direction. So I applaud the governor.
Well, there will be those that disagree with you. I mean, probably someone who would disagree with you would say something along the lines of, this is going to make every single COVID case a workers' comp case, and that's not appropriate, and may even be a taking without due process of law. And so, I mean, really, to just declare an issue decided in favor of a party before there's a lawsuit by a governor without legislation, I mean, that's an issue to me, right? So, and also it may create more workers' comp than should exist or is helpful to exist. But look, I mean, this is above both of our pay grades.
I was going to say, join us for the constitutional class lesson.
We'll talk about this one. We can talk about this one all day.
Session 27.
Yeah, it's very theoretical. The practical reality is the rebuttal presumption. So you got to figure out what you're going to do if you're an employer, and for essential employees, you got to figure out who they are. So, like I said, the literal language will be coming with the red alert. If you don't already have it, you can check it out. That's in the news. Also in the news is we are these days in court by telephone, right? And a lot of people don't like this new deal where there's a phone call trial. I never even heard of this. It's so crazy. Now you have a trial, you get on the phone, right? What do you think of this? Let me just, before you answer that, I go first because I'm more important. We've established that already, right? No,
that's because you have a mute button over there. I can be talking. You just press the button. No one hears me anymore.
Yeah, I have all the power here at the. It's the kind of the opposite of the WCAB. Yeah, where the applicant has all the power. No, my attorneys are concerned about the idea of cross-examining somebody over the phone. I mean, how do you even know it's the applicant? And there's a whole lot that goes into that. And for some people, it's a due process issue. And I think a lot of people are objecting to this whole process. But I think the WCAB, maybe they're just kicking the can down the road a little. They know that if they allow phone trials, you can put in the steps and issues, you can put in the basic arguments ahead of time, put in the evidence. I mean, really, that's all you just about get done in the first day of trial anyway at the WCAB, if you're lucky enough to even get out.
I think baby steps is what we're looking at, and I applaud the division for continuing to look forward and approach it in this manner. I mean, prior to this Monday, if there was a trial, no one showed up and it was just kicked down the road. So not much was accomplished. Knowing a date that you have to appear, that you have to be prepared to discuss the issues with the judge, and maybe if you're lucky, even get something started on the record, that's a positive. I've heard a few anecdotal stories from around the state. A colleague of mine up north indicated that a judge was willing to submit a case at trial, but didn't feel that the instructions allowed him to actually take testimony. So a submission without testimony if the parties had such a case. So I think there's a little confusion in the community as to what the judges can do and not do. As with all of this, we'll kind of feel it out and see where it takes us. There continues to be discussions about the possibility of evolving into video-like trials like we're doing with our depositions, where you can see, confront the witnesses. Again, not maybe ideal as being there in person, but certainly much more interactive than the phone. So I don't have any indication that that's something that's happening anytime soon, but certainly there seems to be an interest to evolve to that if we're going to be in this environment for a prolonged period of time.
Yeah, I just don't know. We just don't know how long we're going to be without being able to physically be together at the board where we belong.
We do belong.
Yeah. Anyway, let's move on past that topic and get into what we're here to talk about today. Is the relationship where the COVID virus is non-industrial and the injury is industrial, or vice versa, how that's going to work. The idea here is that it's not just getting COVID and having COVID that's at issue, right? There's comorbidities, there's overlays, there's people with pre-existing conditions that are industrial, and there's sometimes an industrial COVID on a non-industrial condition. What about that stuff? And that's going to be a major area, I think, when it comes to filing claims, because getting the flu sucks, and you're going to die some of the time. But a lot of the time, you're just going to get better. There are aggravations, but you're just going to get better. But sometimes there's going to be complications, and that's very common in workers' comp. So it's going to be a big part of this book of claims that's going to come into existence, and that's what we're going to explore today. But starting off with the basic rule of compensability, until the governor got involved anyway, the applicant had to prove that it was proximately caused by employment, and they said, look, there has to be this unbroken causal connection. This is the standard. The applicant has to actually prove it, which is why most non-occupational diseases are not work-related. They have to show that it is related to work. Otherwise, it's just not work-related. There's a particular case, South Coast Framing, which really tells the story of how it works in workers' comp. We call it the 1% rule. The idea that causation, it just has to be some causation, not any particular amount of work-relatedness in order for an injury to be considered industrial for purposes of workers' comp. So what happened in South Coast Framing was the guy hurts his neck and his back, and he gets 3 medications by the doctor. He gets Xanax and Ambien by his personal doctor, and it all mixes together, and he dies. Bummer. All too common sad tale in our day and age. So the QME looked at it and said, well, the guy took too much Ambien and Xanax, and the additive effect of these 2 medications was enough to lead to his death. He said of the 3 industrial medications, though, one had no role, one may have had a small role, and one had a minuscule role. Okay, so the defense said this is not significant. This is not even language that should constitute a causal link at all between the work-related injury and the associated medications and the death. And the Court of Appeal agreed and said there's insufficient evidence that the drugs prescribed for work contributed to the employee's death. But then it went to the California Supreme Court, who reversed the Court of Appeal, which is uncommon. And they said no. The employer takes the employee as they find him at the time of his employment. They said, look, death attributable to both industrial and non-industrial causes may support a death claim. And industrial causation has been shown in an array of scenarios where a work injury contributes to a subsequent non-industrial injury. That is, if there is any causal relationship between the work and the injury, even if there's overwhelmingly non-industrial causes, defense loses. The injury is work related. Another quote we have here: an employee may not be denied compensation merely because his physical condition was such that he sustained a disability which a person of stronger constitution or in better health would not have suffered. You take them as you find them, the old eggshell plaintiff rule that we had in college. This is a what they call lighting up case. We say this a lot in workers' comp. Whenever there's we used to use it and we did argue about apportionment back in the day, right? If there's a pre-existing disease which is asymptomatic and it's lit up, that is it becomes symptomatic due to an industrial aggravation, it's work related. So the point here is that the Supreme Court believed that substantial evidence established that industrial medications contributed to the death of the employee. So it rejected the Court of Appeals decision that the employment had to be a material factor in the employee's death. That's not the standard. We call it the 1% rule. If the work is at least 1% or even less than that, I would think, any cause, any level of cause, then it's considered work related. And that's important for this kind of illness.
It is. When that case came out a few years ago, it didn't necessarily break new ground, but
Yeah.
it definitely reaffirmed that standard. And I think most of the cases we're talking about today, as the backdrop for this topic, again, none of them per se break new ground, but thinking of them in the context of the machinations of what can happen with a virus and its consequences are really interesting and really kind of mind-blowing.
Yeah, that's our next two slides. So look at this chart here. Look at these pre-existing medical conditions. So, I mean, you could die when you get COVID and your chances of death are like less than 1%. But if you have these conditions, then your chances of death with cardiovascular disease up to over 10%, right? So if COVID's work related, then your death is work related.
And you know what that slide doesn't tell us, but it's something to think about in the employment context, is that there have been reports about higher incidence of death in certain parts of the population, certain ethnicities and what have you. And certain ethnicities, for example, have higher incidences of these types of pre-existing conditions. So when you start to put all of those things together, you can start to see the potential risk both for the employees and the employers.
In non-death cases, that's going to be interesting, given the case law that came out a couple of years ago on apportionment, where they said genetic factors can be a proper source of apportionment. Remember that?
That can be a certain contributing factor to lighting up of a pre-existing condition for injury too, then I assume.
Yeah, there's no apportionment of that. And that's what we're talking about here today. So, yeah.
You mean the lines of causation and apportionment have blurred? Oh my, shocking.
Let's not get too excited over there, the applicant's attorney. You got it good in the system, okay? Don't complain. All right. So anyway, yeah, so it doesn't matter if the COVID-19 was industrially related if the employment was a contributing cause of death. So if they have a prior award for a heart condition or hypertension, and then COVID-19 is not work related and they die, then it's still an industrial and non-industrial combination that caused the death, and so it's industrial. And there's no apportionment of death benefits. Apportionment doesn't apply to causation of injury, TD, medical, death benefits, anything except permanent disability. So when you have that 1% or less causation linked from an industrial source, whether the COVID is industrial or the underlying condition is industrial, then you're going to get full benefits owed on all those fronts.
For the older population that maybe isn't working anymore, that's where liabilities cut off. Remind the 5-year statute of limitations on that issue.
Yeah, there is an actual statute of limitations on death. And you know what, that's one that kind of works. It's if you take Sullivan on comp, and by the way, we have the Sullivan on comp sections on the bottom of every slide. So if you want to read more about anything that we're talking about, you just can click through to those particular sections. But yeah, I mean, when I did this chapter 6 on statute of limitations, I have a whole checklist at the end. It's like, this is how you're going to lose the statute of limitations argument if you're the defense attorney. There's like 18 of them ways to lose, right? And everyone who practices workers' comp knows that unless you are exceptionally diligent on the defense side, you're going to lose statute of limitations. I've won a couple of them by being exceptionally diligent, but it was unbelievably hard. But statute of limitations for death claims is different. I mean, a lot of times, it does work. If you die too far away from the date of injury, you're not going to get death benefits. Otherwise, we'd have million-year-old claims, right?
Yeah.
Yeah, it'd be Jurassic Park claims. So that's that. Now, there's also the possibility that an employer could be liable for treatment of a COVID-19, even if it's not industrial. Let's say that you need to treat the COVID in order to treat an underlying condition. Do you have to do that? Is it work related?
You have to treat the underlying condition, most certainly.
There was a particular case where an applicant had to do a weight loss program. He had been a robust gentleman for quite his whole entire adult life, right? He had been overweight, and he had a back and elbow injury. And they said, you know what, we can't treat this until he loses some weight. And the defense said, wait a minute, we don't have to pay for his weight loss. That's ridiculous, right? And they lost because the board said, no, you have to treat the weight loss in order to treat the underlying work-related injury.
And that Braywood case is the standard, and it still is the standard today, almost 30 years later.
Yeah, that's true. But the employer is not required to furnish medical care for a non-industrial condition if there's insufficient evidence to prove that the treatment would cure or relieve the industrial injury, or that it's needed to treat the industrial injury. So there was a case where the guy says, I need a heart transplant. I have a neck and back injury. In order to treat my neck and back injury, you have to provide my heart transplant, which is, $1 million or something, $500,000 or something like that. At the time, I think it was a lot more, but it's still exceptional treatment, right? But the board found, it was a writ denied case, but they found that the transplant would neither directly nor indirectly cure or relieve the effects of the neck and back injury. So they didn't give it to him. And then the same thing happened with a guy trying to get a liver transplant. I think these people probably need transplants, and they say, well, maybe I could use this theory in workers' comp and say that you can't really treat the industrial without treating this condition. And in this case, the Doak case, the applicant lost as well. They found that it was needed, the liver transplant was needed to improve the overall health and to keep him alive without regard to the industrial injury. So, I mean, I'm Irish, so if I ever got an industrial injury, I'd definitely be looking for that liver transplant. But you do see this happen sometimes.
The bars being closed probably just extended your life by at least 6 months.
Well, they're still selling alcohol. Yeah, that's what people are drinking a lot less when they're sitting alone at home being sad. It's not really a good thing. Anyway, so that happens. If the applicant's industrial heart problem and non-industrial COVID contributed to the need for hospitalization, then the employer would be fully liable for the treatment, right? So now, if the employment required industrial knee surgery but could not have it because of COVID-19, what would the implications of that be?
I mean, because there's a COVID outbreak, or because they have COVID?
Because they have COVID.
Well, that would be an intervening non-industrial condition that quite possibly would have to be treated under Braywood so that they could resume their treatment and have their surgery.
Mm-hmm.
Although it wouldn't surprise me if that was litigated and the courts treated it like a transplant.
Mm-hmm. I think you're right. The opposite is also, if you have like an underlying work-related condition, and here comes COVID, and COVID's not work-related, then there also could be an aggravation situation there. So I always get myself confused when I talk about this. I'm like, which one is work-related, which one is not? It doesn't really matter. The point is that if either one of them is industrial, underlying condition, or the COVID, and they combine to cause an aggravation, then you're liable for that.
In these cases, I'm assuming in these fact scenarios, we're talking about probably post-stipulation type cases, although it could be while the case is still ongoing. But in a post-stipulation case, what are you going to do from a practice point of view? You're going to look back at the stip. You're going to look back at the underlying medical. What was really agreed upon as an industrial condition? Was it limited to the hypertension? Was it the whole hypertensive system?
Mm-hmm. Yeah.
I know that the thorough attorneys at Sullivan and Associates are always conscientious about how the injury is defined, and from an applicant's perspective, again, we want accuracy being the theme of the day, starting with my picture. Accuracy is important. And so we need to be sure that that the conditions as diagnosed and as are awarded are thoroughly documented, because issues like this could arise, and those questions will need to be answered.
That is really, I bet you see a really wide disparity in the diligence of defense attorneys filling out STIPs. To me, if you're not, the two areas you need to be absolutely paranoid about when you're a defense attorney is settlement docs and STIPs and issues. If you don't get those STIPs right, it's really problematic. And there's a 5-year rule, right? So if you want to claim an aggravation of an underlying industrial injury, then you have a 5-year limitation from the date of injury to do that. So so this is what we're getting at next, as we talked about, is the COVID is industrial and aggravates the non-industrial condition. If the COVID is not is industrial and aggravates a non-industrial condition, then to the extent that disease is aggravated or there's a need for treatment, then that's compensable, right? So if you have an employee with a non-industrial chronic lung disease, he dies by getting COVID-19. His underlying chronic lung disease is not work related, but he gets COVID at work, and now with the perception it's easier, then the death is compensable.
Correct.
Yeah. And if
presumptively for some workers now.
Yeah. If you have to get medical treatment like hospitalization because both industrial COVID-19 and non-industrial lung condition, then the employer is fully liable for that treatment because there's no apportionment of medical care. So the two things have combined, industrial and non-industrial, have caused the need for treatment. Then it's and if you get a permanent aggravation of the lung condition, then the employer could be liable for the increased permanent disability, right? If there's a permanent, because remember, there's no apportionment for anything except permanent disability. So if you have a non-industrial and industrial condition combined to any extent, the industrial condition, you're not really talking, and anything is necessary because of the combination of the two, then you're going to have full liability, except for permanent disability, because you get a portion of permanent disability. So, I mean, most people who have COVID-19 have only minor, like, flu symptoms, and they get all better. So you could have a situation where you need the medical care because the COVID's work related and it aggravates an underlying condition, and you need the medical care, right? But what happens when we fully recover? That's the question. Do you have any more liability after you provide that in this treatment? I think the answer is no. We have a case here, Ref versus WCAB, and in that case, the nurse contracts occupational pneumonia. Most people mispronounce it as pneumonia, but there's a P there, obviously. It's right there in front of your face, right?
That's pneumonic.
That's
Mnemonics?
pneumonia.
Yeah.
Oh, yeah. Nurse contracted occupational pneumonia, okay? So she had pre-existing dormant common variable immune deficiency, CVID. So it looks like COVID, but it's not. I don't even know what that is, but it sounds pretty bad. So she's got this underlying condition, and she gets occupational pneumonia because she's at work being a nurse. And then the treating physician says that while the pneumonia may have worsened the dormant common variable immune underlying condition, there's no evidence of permanent lung damage from the pneumonia. So she has this problem with her lungs. She gets pneumonia. She has a workers' comp claim. She gets work-related treatment, but then she gets better and she gets back to her bad state that she was in before she got the pneumonia, meaning that there was a temporary exacerbation, not an aggravation of the underlying condition. And the board concluded that that the defendant was no longer liable for the medical care, right? Yeah. So the standard is whether the medical evidence indicates within a reasonable medical probability that the normal progression of the non-industrial disease or condition would have resulted in disability regardless of the industrial injury. It's that same causation standard. You have to show that there's a causal relationship between the COVID and the benefit being claimed, whether it's medical treatment or death, or for permanent disability. The difference is between what we call a permanent aggravation, so that your permanent disability is increased, and just a temporary exacerbation such that you get a little bit worse and you go back to your bad state before it even started it. So in Ref, it was because the evidence established the applicant suffered a 2-month temporary aggravation or lighting up, right? Just a 2-month I would call it, I wouldn't use the term aggravation. In my mind, I like to make the distinction between aggravation and exacerbation or something like that. But there's no legal basis if there's no causal connection. You agree with
I
me?
would concur, and I
Yeah.
think that was the medical analysis in that case, and that could prove to be the medical analysis in some of the scenarios that we are talking about. Of course, case specific, fact specific.
Well, I think we'll see this. I think we're going to see a lot of this. I mean, because let's face it, the toughest cases are going to be the death cases, and almost inevitably, there's going to be some, non-industrial reality to some of these, right? And then there's going to be the treatment cases, and it's not just applicants, right? It could be medical facilities that have not gotten paid and file liens, or send bills saying, hey, this was work related, right? They're like, no, the applicant never filed the claim. Well, we're filing one. You can see that happening, right? And this, who's responsible for the care if it's significant care, even if the applicant gets better and isn't really interested, because in most cases the applicant will get better and won't be interested. And then there's going to be a fight in cases where there's underlying permanent disability over whether or not there's an aggravation or not, and then whether the 5-year rule applies or not. Because even if there is an aggravation, if it's more than 5 years, you can't get new increased permanent disability, right? So there's going to be a lot of these fights, I think, and that's kind of the framework for how it's going to shape up, I think.
And as they learn more and more about the chronic nature, assuming that's where it goes, of some of these conditions, I think I spoke with 3 exposed people positively contracted the virus in the last week or so, and all 3 of them reported very similar ongoing symptoms. Mind you, all 3 of them are actually back to work, but they have residual loss of sense of taste and smell. One of them had some ongoing cognitive issues, and she was actually ventilated. So I don't know about the prolonged damage from the loss of oxygen, or decrease in oxygen. And every single one of them still didn't feel like their respiratory or pulmonary function was back yet. That's still early, and hopefully they'll get a better recovery. Someone who contacted me today is actually a public safety officer and highly fit, former Marine. I mean, could run a 6-minute mile in a day. I mean, he was, so he probably had excess pulmonary function, and what that ultimately measures and if there's any residual disability just remains to be seen. But I think I said it last week, I'll say it again. It's all about the medicine, stupid. And as we learn more about the medicine of this problem, it'll help define
we don't know
these
yet,
issues. We
right?
just don't know.
We don't know how much. I mean, it doesn't seem like there'll be a lot of permanent damage, but we don't know.
Don't know.
We don't know. So we'll have to see.
I mean, they're kind of laying the groundwork for us, because they've, and for our topic today, they've already suggested, and the slide shows it, that the effect of the virus on those with pre-existing conditions is much greater than those that don't. Not that those that don't can't be affected.
Right.
So our radar has to be up in the workers' comp community on both sides of the bar with respect to these concerns.
Yeah. Now we're going to tell you about how you get a successful COVID-19 claim without actually having COVID-19, industrial or non-industrial. Are you ready? And we're going to talk about psych too. We don't want to forget that. That's a big portion of it. I mean, I can see like getting COVID-19, the psych, and then the psych stays with you even though the COVID-19 is gone. But we'll talk about that next time. What I want to talk about now is you get sent home, right? And you're walking to the bathroom and you trip over the rug and you break your neck. Work related? Well,
you're asking
no.
an applicant's attorney?
You're no, because you're at home.
I need a button that just says yes.
Yes.
Yeah, no. I'm not that extreme. I'm just teasing.
You do your job, Adam.
Thank you.
I respect that. I gotta have someone to fight with. If you're not going to be unreasonable, then I'm always going to be unreasonable.
Listen, I'm an employer as well, and I appreciate that my people are working at home, and I want them to be safe as well. And
well, the bottom line is,
these concerns are going to come up, unfortunately.
Well, look, there's a couple of doctrines to be considered here, and we'll go through them. But I think the bottom line here is that when you are at home, that becomes your workplace. And there's a stay-at-home order. Now, employers are being told that the employers can't work at work and that they have to work at home by the government. So they're not necessarily voluntarily asking people to work from home. This is not necessarily a directive coming from the employer. It's coming from the government. But everybody's got to go home and work there. And I'm working at home, and we're all in our jammies, and we're doing this thing, right? Okay.
Oh, the mental picture.
There's a couple of I mean, I could have gone another way with it, and, you know, made it a lot worse. So you should just be grateful you're not dealing with me in my worst form. But anyway, so yeah, there's a couple of doctrines to be considered. Like, what happens when you're injured at home when you're working at home? And the first one is the personal comfort doctrine. Now, under the personal comfort doctrine, it's not this way in all the other states. In fact, this is an extremely liberal position that California has taken. But fundamentally, if you are at work and you're doing things that are not directly inuring to the benefit of the employer, doing your nails, go to the bathroom, things like that, you know, walking over, talking to your buddy at the water cooler, anything that you can think of, really. These kinds of acts are considered to be within the scope of employment because of your presence at work, and that's really all there is to it. You even have parking lot cases with a premises line rule. Did you cross the line into the premises? You have a series of cases about injuries right outside of work. You have break time injury cases, lunchtime injury cases, like were they at work, were they on the clock, off the clock, was it recreational issues, you know, ESI test, you know, did the employer sanction the activity? So if you can connect it to work, then generally speaking, the employer is screwed, even if it's really not something that came from work, it's their location enough. And that's the personal comfort doctrine. Here's a quote from Fireman's Fund back in 1952. The rule is broad enough to include the majority of employees' acts upon the employer's premises, such as eating lunch, getting a drink of water, smoking tobacco were not forbidden by the employer.
1952.
Yeah. Attending to the wants of nature. I like that one. Changing to and from work clothes and many others. Now, if you're doing something that's fundamentally personal, like an assault case where it's a personal assault, but you happen to be on the work, it won't be work related. But those are rare cases, and they are carved out from this general rule.
You know, those line of cases, they focus on two major issues. Are you being paid? And do you have the consent of the employer? And, you know, just take, for example, employers that receive the PPP loans. I mean, they have to keep their employees working.
Right.
So there's no dispute that someone is home working if they're collecting their loan, right? And using it to pay their employee.
Only if they're asking for forgiveness.
Well, that's true too.
Yeah.
That's a good point.
Yeah. Yeah. So you're always trying to box my employers in, Adam. I don't know what's with you, man. The Santa Clara Valley transport case, the Tidwell case is instructive. It's just
who wouldn't seek free money? Anyways, that's whatever.
Yeah, that's not really the topic for today's session, but thank you for your exploratory tendencies and
turn into channel
keeping things
11
interesting. Yeah. So anyway, in the Tidwell case, what happened was the board said the personal comfort doctrine could be applied to an employee who works from home. And in that case, the applicant had a disability that was being accommodated by being allowed to work from home. She fell from her wheelchair while using the restroom and got injured at home, but she was being allowed to work at home by the employer. And the board found that the home had become her workplace, and it applied the personal comfort doctrine and found that injury to be work related. So, you know,
let me ask you a question.
That seems like if you're at home, you're at home, right? And you get injured and you're a stay-at-home order, then it's work related.
Well, let me ask you this question. Don't you think as the employer, and I'm asking you now as an employer representative, that you can actually put some limits on the time that people are actually on the clock at home so that, you know, if something were to occur at home, but beyond the time that they're mandated to work, that there is some protection for the employer there? Are there some parameters you can put on it to avoid this liability?
It's tough, isn't it? Because, you know, I mean, just to follow, look, I mean, I'm an employer too, right? So I have, you know, over 150 people in this firm are working from home right now. And I talked about it a lot with HR and with our executive director. And, you know, complying with wage and hour in California is almost impossible just being a regular employer. I mean, if you're small enough, you simply cannot do it, right? It's so complex. You know, people, you know, go to lunch too late, they get an extra hour. And if they go to lunch too early, or if when they clock in, when they clock out, when is someone considered to be on the clock, right? And when are they not on the clock? And there's a whole lunch breaks cases and the off premises. And what if they leave their house to go get lunch, right? And they're off the clock? It probably wouldn't be work related. Whereas if they ate lunch at their house, it would be work related, right? So how do you know whether they're on the clock or not? And the answer is you just don't. I mean, right now what we're having to do is people clock in and out on their computer, but we don't know what they're doing because it's impossible to supervise them. They're not on premises. I mean, unless you want to insist on cameras being installed in their house, which raises a whole other host of creepy issues.
I'm not advocating for that.
Yeah. So I mean, I'm thinking that employers are a severe disadvantage here because with just a incidental amount of sophistication on the part of an applicant, they'll be able to demonstrate that any injury that occurs at home is work related. You agree? You got your big spoon and your big fork out with your big bib, and you're ready to you're ready to feast on these cases, aren't you? Look at you.
In my pajamas, yes,
terrible.
of course.
Capitalizing on the misery of others.
Oh, come on. It's a tough position,
Yeah.
and
it could be shocking to employers to realize it.
Yeah.
It's like anything that happens to them at home is work related.
And but they need to be informed because they might just assume that it is not, and they wouldn't want to be foul of the law and not properly providing benefits with all the protections that come from a no-fault workers' compensation system, right?
Yeah, that's true. And then it gets worse for employers and better for applicants because of the application of home as a second job site with the going and coming rule. Now, the going and coming rule, well, it says that if you're going to and from work, then it's not work related if you're in an accident. Usually it's a car accident case, right? And the going and coming rule, as we all know, is riddled with exceptions, just riddled with them. Like this section on Sullivan on comp is really long. It's like 18 different exceptions of going and coming from work. If home is a second job site, then if you're going to and from work, is that an exception? And we have some cases we talked about here. Now, generally speaking, the courts have been reluctant to allow employees on the way home to say, well, I did some work at home, therefore it is a work-related injury when on my way home from work. The courts don't like that. They have language saying we're not going to create a quote-unquote white-collar exception in workers' comp where somebody can say, well, I did some work at home and therefore it's work-related. They don't like that, but there has been some precedent for it. So here's a Bermal case, and here there was a legal secretary who was in a car accident driving home from work, and the injury was found compensable where the employer knew that she normally took depositions home for translation and approved the practice. So here what happened was she's a court reporter, she goes home, she works on depositions. The employer knows she's working at home, has approved it, says, yes, work at home, and they found it work related. And that was a big deal in this case because it's not normal. Right, and more in line with normal is the Smythe case, where there's a Supreme Court and there's a college instructor, and he drove home and he died in the car accident, and he found it was not compensable. It was established that working from home was a choice, not a requirement of the employer. So just because, and look, we all do this, right? Lawyers do this. We go home and we do work at home, and the employer doesn't require it. You could do it in your office, but if the employer does require it or evidently approves it, right, approves of it, so it can make some pretty muddy waters. Now, in the case of the current situation, it's likely that it's going to be considered work-related because you are working at home. That is sanctioned by the employer. There's no way around it.
When I speak to other employers, I hear the following pretty frequently. We're on reduced staff. They go in at shifts. They're working sometimes at home, sometimes at the office. So now the lines are blurred further. So they're driving to the office to pick up their work, to bring it home, to do the work at home. I think that the exception is going to come up in those fact scenarios more frequently than otherwise.
Yeah. So what about this though, Adam? What if I said to you, you know what? The employer did not sanction this. The employer did not require this. There is a stay-at-home order issued by the government. And the reason that these people are working at home is not because the employer sanctioned it or required it. The employer was required by the government to allow people to work at home, and so they did.
So you're going to sue the government?
No, I'm just saying it's not work-related.
Well, I think you lose because, again, you listed a line of cases and thought earlier pretty quickly, but to remind the people, the rule of law, if you are providing a benefit to your employer, which you are doing by working at home and contributing to their bottom line, I think it's going to be hard to get around that just because the government mandated it. Your employer is benefiting from the work that you are doing, and it is being sanctioned or approved, as you indicated earlier. I think that's a strong, probable AOE COE case for the injured worker.
But Adam, what if I were to argue with you?
That's never happened
What if
before,
I were to
Michael.
say, hey, the premise behind the idea that there's liability for at-home injuries is that the employer has sanctioned it, approved it. That's the premise. It's the employer requiring it that makes the employer have liability when the employer does work at home.
I would still take that case every time because my first question, Mr. Sullivan, tell me how Adam Attorney contributed to your bottom line by the hours that he billed working at home that he otherwise wouldn't have done if you mandated to been in the office where he couldn't go.
Yeah, it doesn't sound like a question. It sounds like just a statement in a question's form.
I rest my case.
Which is, of course, cross-examination.
That's true.
I'm not answering your questions, Adam.
I'm not putting you on the spot.
But I think it's important to point out that like the going and coming rule exception, a home as a second work site, that may be a viable argument, but it's probably less of a viable argument, although a clever, aggressive defense attorney might argue it if you just have an injury at home, because that's really more of a personal comfort doctrine issue, right? I mean, it is the workplace. It's the idea about the employers approving, sanctioning, requiring people to work at home. That idea applies mostly in this going and coming rule situation where you get hurt going or coming from work. But if home is established as as a workplace, then it doesn't really, it's not a precondition of compensability that the employer is sanctioning, requiring it. It's just allowing it is enough. I mean, and a defense attorney, I'm sure, will make an argument that this was required by the government, and therefore it shouldn't be, the premises rule shouldn't apply in this case. But that will be weaker than an argument that's made in the context of the going and coming rule exception.
I could see another issue arise when the government starts to pull back on the mandate who has to work at home and who doesn't.
Mm-hmm.
And maybe you have an at-risk employee with some underlying condition that reaches out and says, hey, I'd like to continue to work at home. So now where's the line drawn there?
Yeah, that's a good point, because as we slowly start to go back to work, people may say, hey, I like working at home, and the employer says, hey, I like not paying for office space, so let's do that. Well, now it's different, right?
Yeah.
And also it may be that, there's just more working at home, more employer sanction. So it's like that. It's sort of interesting because in the present environment, everyone is ordered to be at home except essential workers. So like we talked about last time, if you're at greater risk than the general public, then it's compensable, right? Well, if everyone's ordered to stay home, then the essential workers are almost by definition, you would argue, at greater risk than the general public. I mean, I would, as a defense attorney, say no, because they're just part of the general public, but you get my point. But as people start to come back to work, then it is less and less of an argument that you have more risk as an essential worker than you do as a member of the general public, because
True.
The general public is back at work to some extent and to more and more of a degree. So that argument sort of dissipates. But now, my friend, you have your presumption. So it may not really matter. They're going to give it to the applicant unless we can show why not, and that generally means talking to AME or QME into believing it is not at all related to. Yeah, so it's tough. Yeah. Okay. Well, I think we finished a little. We have a few minutes to spare, so we'll spare you the few minutes of of the extra workers' comp. But I wanted to show you our slide. Here's our slide. If you want to get our, again, I'm going to emphasize we did this big book on COVID-19. It's always updated. It's really bitching. It can answer any questions. Here's our contact information for Sullivan on Comp. If you have any questions or if you have any comments, people, there's like a lot of people listening to these things, and we're getting a lot of questions, and we try to answer them all. So feel free to ask questions or make comments. We always appreciate any feedback and your support of our product. And once again, Adam, thanks for coming in and doing this with me. You've always been a great co-speaker, and I think it's important to educate the community. And so it's you're not getting paid or anything for this, so it's appreciated.
Thanks for having me. Everyone be safe.
Yeah. Until next week.